Good afternoon.
Good afternoon. We'll hear from the appellant.
Yes, sir. I'd like to reserve 3 minutes.
That'll be fine.
Thank you. Your Honor, Mike Alston from Chattanooga, Hush Black Bull firm, along with my co-counsel Caroline Shea, here to represent the appellants in the matter. And good afternoon to you all. May it please the court, the appellant's primary argument is that the trial court, the Chancery Court, erred in ruling that the appellee holds rights of first refusal, and if it's okay with the court, ROFRs, because it's hard to say rights of first refusal, ROFRs over the subject property. The ROFR that Prior Bacon invoked were not intended to obligate the appellants and were not intended to benefit the appellee, and they had long since expired. And even if the ROFRs had not terminated, Your Honors, they would be void as unreasonable restraints on alienation and void under the rule against perpetuity. Secondarily, if the court decides that the appellee should prevail, then the trial court abused its discretion in giving the appellee an exclusive right to purchase, contrary to those ROFRs, as opposed to making those all of the descendants of Mary Hahn able to offer on the property. As you can see, the record is fairly extensive, and the facts are even probably as extensive as the record, so I'm going to do my best to cut those way down, Your Honors. First of all, Mary Hahn gave portions of a 23-acre plot to her 4 children as the grantees and their spouses as the grantees. So there are eight grantees in this case, and only 8 grantees. She retained a portion of the property and gave her kids in 1953 the other portion of the property. The property was bestowed to them through 4 deeds. And the deeds all had restrictive covenants, including a ROFR that did not run with the land and was personal and specifically named just those grantees in the contracts. The ROFR read as follows: in the event that the grantees herein desire to sell a part or the whole of this property to anyone other than the descendants of grantor herein, said part or whole of said property must be first offered to the grantor herein and her adult descendants, and then to the owners of the said 22.59 acres, more or less, exclusive of the owners of the lots in the subdivision in the northwest corner of said tract at $1 above the bona fide price. And they should have 10 days to either accept or reject that offer. And so it was limited to the grantees, those 8 souls. And the principal property involved, Your Honors, was 4 River Vista in Chattanooga and the Berglund Trust parcel in Chattanooga, all part of this 23-acre plot. The appellants, as to 4 River Vista, the appellants, Sandlin and Poynton, entered into a contract or went under contract with a potential buyer for $1 million. And the buyers, however, terminated the contract in part because of the ROFRs. While Mr. Bacon's complaint, the appellee's complaint, sought specific performance, the actual performance he sought was to have all of the so-called adult descendants be able to bid on or match plus $1 any bona fide offer, as opposed to having an exclusive right, which is what the Chancery Court gave them. The second piece of property is the Berglund Trust parcel. The Berglund Trust parcel was part of 4 River Vista at one time, but Miss Sandlin and Mr. Poynton sold that property to the Berglund Trust in 2020 for $30,000. Similarly to 4 River Vista, the complaint in the case and the summary judgment in the case and the arguments in the case asked for the adult descendants to be able to bid on the property for $1 more, as opposed to an exclusive right. And so that is very distilled facts, Your Honors. The arguments in the case, our primary argument is that Mr. Bacon holds no right of first refusal on any of the properties at issue because the subject ROFRs have extinguished or are unenforceable under tenancy law. The ROFRs must be interpreted under the framework of the fundamental principle in tenancy law that deed restrictions are disfavored because they are in derogation to the free use and enjoyment of property. Because of this, any ambiguity in the provisions of the ROFRs must be resolved against enforcement. And to the extent that they were enforceable as drafted, the ROFRs have extinguished. First, because they do not bind the appellants. As I stated earlier, the ROFR speaks in specifics about the fact that they're triggered when one of the grantees desires to sell. Well, the grantees, as of 2011, are all dead. They're no longer with us. And so...
What about the argument, I think, that opposing, and you are correct, the facts are quite lengthy and convoluted, but as best I understand it, assuming your argument is correct, that it only extended to the original grantees, what about the argument that subsequent transfers included that same language in the new deed, such that even if it had expired, it's back again because it was put in new deeds?
Yes, Your Honor. That is what I would term the new ROFR or the subject to ruling of the trial court. Subject to provisions and clauses are not sufficient to create a new ROFR obligation. They are there for notice. They're not there for contract. Other jurisdictions say they're words of qualifications and not of contract. Tennessee courts have similarly held that the fact that a conveyance is made subject to restrictions set forth in some other deed or document will not, without more, make the restrictions applicable to the property. So we would say, the appellants would say, that those don't create enforceable new ROFRs. The other piece of that is that the subject to clauses aren't sufficient, and the Phillips Court held this sufficient to reflect an intent of subsequent purchasers to create a new ROFR which ties them to those adult descendants in this case. So that the argument is that yes, they're there, but the effect of those subject tos is not to revive or create a new ROFR. Okay? Our second extinguishment argument is that adult descendants really means only the Hahn children, Mary Hahn's children, as opposed to all descendants going forward. The language in the ROFR is itself ambiguous from the face of the deed. At one point, the ROFR calls it adult descendants. At one point, it calls it descendants. So if adult descendants and descendants are the same, are synonymous, then that renders meaningless and superfluous the word adult. Moreover, and frankly, probably more importantly, the adult descendant phrase is not common in Tennessee law, and it's not common in Tennessee real estate documents. In fact, there's only one case in the state of Tennessee jurisprudence that we could find that actually used the phrase adult descendants. Believe it or not, it was a case about this same family compound. It was a 1970 case called Foster v. Hahn, in which Daniel Hahn ROFR was involved, and it related to the payment of a real estate commission associated with a sale under the ROFR. The three surviving children in that case, the three surviving Hahn children, described themselves as the adult descendants. Not some of these, not some, but the. And the problem was, there were other adult descendants alive at the time that were not those children. So the first generation believed that they were the only ones that this ROFR was there to protect. And Ms. Sandlin, who's here today, Ms. Sandlin was of age at that time, and she was not a party and was not described as an adult descendant. So we would submit that, if nothing else, would point to an ambiguity. And in fact, Ms. Sandlin and Mr. Poynton have never received an offer in 72 years since these deeds were put in place, never received an offer under the ROFR. So it was clear that the family believed that this was over when the children died, when Ms. Hahn's children died. So because the adult descendants is ambiguous in this context, the court should narrowly construe that term and interpret it to include just the children of Mary Hahn, and who are all deceased at this time. And so we would ask that the court would reverse the trial court on that ground. And remarkably, I'll say parenthetically, that the trial court didn't even cite or mention the Hahn case in his decision. Finally, with regard to extinguishment, the deeds themselves are very clear in saying that they are made solely for the benefit of the grantor, Ms. Hahn. And so that would be inconsistent for the rights to flow in perpetuity, but it would be very consistent with her wanting to protect herself and her immediate family.
Counsel?
Yes, ma'am.
Does the record reflect any reason why your clients would not accept basically the same purchase price that that they had originally sold it for to different parties? Is that in the record at all?
It's only in the record to the extent that there's been no actual offer made under the ROFR. And if there is an offer made under the ROFR, it needs to go to all the adult descendants as opposed to just one. There is no evidence in the record as to what's in their state of mind about that. And so that's our position on that. One final point on the extinguishment, Your Honors, is that even the appellee's own grandfather, Charles Hahn Jr., who prepared and drafted the ROFRs himself, didn't follow the ROFRs, didn't give the notice, didn't seek offers from adult descendants, and he drafted them. And so that, we believe, is strong evidence that level of the family thought it died when they died. Okay? The ROFRs are also void as unreasonable restraints on alienation. They limit the right of an owner to dispose of his property, and so they could not dispose the property without unfettered, so to speak. And there are problems with duration. There are problems with the boundary line of the properties. There's problems with making sure you have all of the potential adult descendants under their interpretation. And so we submit that these are unreasonable restraints on alienation as well, Your Honors. And then lastly, they're void under TUSRAP, Tennessee Uniform Statutory Rule Against Perpetuities. That act modified the common law, as you know, to give a 90-year wait-and-see period. And of course, it's not been 90 years yet, but that act said it superseded common law RAP, and under common law RAP, these would certainly have been violative and void. But it to the extent that it did not, that it didn't replace it, if it's applicable, then the common law RAP would apply, and in this instance, they would be void under the common law RAP. Very, very quickly, because my time is nigh, the trial court abused its discretion in giving Mr. Bacon an exclusive right, as opposed to allowing the offers to be made to all of the descendants under their theory. Thank you, Your Honor.
How many would that be?
Pardon?
How many that would that be?
Currently would be 35 descendants strewn all around the country, okay, and then 11 homeowners. So you'd have to go primarily to the descendants under their theory, and then secondarily, if no descendants will make an offer, then you go to the Hahn Hill property owner. So 46, I believe, Your Honor, right now, that's our best estimate. Remember that the boundary lines are not clear, and there's actually even a portion in the ROFR that says a portion of that subdivision is opted out of the ROFR. So it's onerous, Your Honor.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon. Can you hear me? I'm Elizabeth Donovan, and I represent plaintiff appellee Pryor Bacon III and his mother, third-party defendant and appellee Jennifer Hahn Bacon. The Bacon's position is, of course, different from the appellant's position. The trial court held that the Hahn Jr. ROFR, the Poynton ROFR, and the Sandlin ROFR are not perpetual. They are personal contractual obligations binding on the original grantees only, Mr. Hahn Jr. as to the Hahn Jr. ROFR, Elizabeth Hahn Poynton as to the Poynton ROFR, and Ms. Sandlin herself as to the 1969 Sandlin ROFR, unless a new grantee agrees, and this is the subject to argument Judge Davis, you referred to, unless the new grantee agrees, like the Berglunds and Mrs. Poynton did, Berglund's did with respect to River Vista, and Mrs. Poynton did with respect to the Hahn Jr. Triangle and the Hahn Jr. Tract 2 and the Berglund Trust parcel, unless somebody else agrees specifically by reference in the deed, in which case a new obligation is created and the new grantee is contractually bound to honor the right of first refusal. That's the first exception. And the second one, which is frankly the one that's more significantly at issue here, is that the property is transferred gratuitously, either by gift or inheritance, in which case the transferee, like Ms. Sandlin with respect to the 1998 Sandlin tract, she got that from her mother. Her mother was the original grantee and the original obligee. And like the Sandlin Trust that got the 1969 Sandlin, or 6 River Vista from Mrs. Sandlin, who was the original grantee of the Sandlin ROFR, and the Berglund Trust, the Berglunds agreed to undertake the obligation, but when they transferred it to their trust, that also was a gratuitous transfer, and it did not eliminate or extinguish the contractual obligation. Obviously, if a mere transfer, if a gratuitous transfer could extinguish someone's obligation, anybody who had a contractual obligation in deed that they didn't care for would turn around, transfer to a trust or an LLC they controlled or a straw man. They would eliminate that onerous contractual obligation, and there'd be nothing that the grantor could do about it. That simply isn't the law. The Bacons believe that the trial court's ruling comports in every regard with Tennessee contract law and with the specific and unambiguous language of the ROFRs at issue. And they ask that you affirm that decision on the validity and enforceability. And with respect to the River Vista ruling, which is what I'm referring to as the order that Ms. Sandlin and Ms. Poynton sell for River Vista to Mr. Bacon, the Bacons ask you to dismiss that without consideration. Ms. Sandlin and Ms. Poynton do not have standing. The only parties that were potentially harmed by this were the adult descendants. And in fact, when they filed their motion to alter or amend, Ms. Sandlin and Ms. Poynton, Ms. Sandlin and Mr. Poynton characterized the River Vista ruling and assailed it on the grounds because it, quote, deprives the remaining Mary E. Hahn descendants of their right to exercise rights of first refusal as to 4 River Vista, close quote. They made no argument that they were harmed. The only person before this court who was affected by that ruling is Jennifer Hahn Bacon, and she does not appeal. And we urge you to do what you all did in Ryan versus Stanger and assume that the adult Hahn descendants, when they decided not to appeal, were, quote, content with it, quote, and you should not allow Ms. Sandlin and Mr. Poynton to appeal for the adult Hahn descendants. They themselves weren't harmed. In 2018, in Hamilton County versus tax year 2011 delinquent taxpayers, this court ruled that the city and county's briefs, or it struck the city and county's briefs because both were going to be paid no matter what. Same things here. No matter what, Ms. Sandlin and Ms. Poynton have to sell for River Vista. If the ROFRs are valid and enforceable, they got to sell it. It doesn't matter whether they have to sell it to Mr. Bacon or somebody else. They have to sell it. The harm comes from having to sell it, not coming from having to sell it to Mr. Bacon. They obviously don't want to do that, but personal animus is not justiciable. It's not a legal harm. I think I disagree significantly with the argument that Mr. Bacon didn't ask for this specifically. He said in subparagraph B of paragraph D of the prayer for relief, he asked the trial court to order Ms. Sandlin and Mr. Poynton, quote, or to, quote, sell for River Vista for $1 million on the terms and conditions of the Clements-Evatt contract that are consistent with the Hahn Jr. deed and the Poynton deed to the adult Hahn descendant who exercises the Hahn Jr. ROFR and the Poynton ROFR. He asked for that relief, and that's the relief the trial court granted. He was the only one who had done so. In fact, the trial court summed it up and said, quote, and in fact, lo and behold, that's what I put in my opinion, that it has been specifically requested. That's why it's in there. There's no question, but they knew this the entire time and that they had an opportunity to argue. I can't think of an argument that applies to the sale to Mr. Bacon that doesn't also apply to the sale to everyone else. And Mr. Alston, in fact, said in the motion for summary judgment hearing, quote, and then Mr. Bacon has attempted to exercise the right he claims under the 1953 deed for that property to exercise a right of first refusal. That is what's before us. There was no question that Mr. Bacon's was seeking to buy for River Vista. Your Honor, with respect to their arguments that the rights of first refusal died with Mary Hahn and with the original grantees, your decision in 1970 in Foster versus Hahn answers that conclusively. They did not die with Mary Hahn or with the original grantees, and I'll tell you why. Mary Hahn died in June of 1967. Daniel Hahn, one of her sons, died either shortly before or after her. In 1969, Daniel Hahn's administrator, the administrator of his estate, received an offer from an outsider to buy the property for $25,000, and Mrs. Hahn's estate and her 3 surviving children exercised that right. If the right died with Mrs. Hahn in 1967, it was not available to her estate or her children in 1969 to exercise. Similarly, if it died when the original grantee dies, it died in 1967 when Daniel Hahn died and was not available in 1969 for Mrs. Hahn's estate and her 3 children to exercise. There is ample evidence inside the deeds themselves. The enforcement provision specifically refers to the heirs and assigns of the grantee and holds them liable if these obligations are not followed. Their argument that the entire contract, that these provisions are solely for the benefit of the grantor is simply a red herring. That provision, they've taken it out of the sentence, the paragraph, and out of context. It applies to the entire contract, and it does not modify or alter in any way, shape, or form the rights of first refusal at issue. Their argument that the rights of first refusal are not transferable by, like I said, gratuitous transfer I've already addressed. The subject to we've already addressed as well. There are a couple of other there's some other evidence that these didn't die with Mary Hahn or her children. For example, in 1969, when Miss Sandlin purchased the 1969 Sandlin tract, which is part of 6 River Vista, she created, or at least acquiesced in creating, a brand new right of first refusal. It hadn't been subject to, this was part of the property that Miss Hahn had retained. This was a brand new right of first refusal. Her position is that it was imposed on her property so that she didn't have rights that were superior to her aunts and uncles' obligations on their property. But again, if it died with Miss Hahn in 1967, there was nothing for it to comport with in 1969. In 2001, Mr. Poynton himself wrote a letter to all the Hahn descendants, and he said, quote, "We believe that our parents and our generation have always considered these restrictions to apply to and end with our parents," close quote, but they're here today saying, actually, it died with our grandmother. That's utterly inconsistent.
Counsel, let me.
Sure.
We need to simplify things for me.
Okay.
Does this entire matter turn on what was meant by the term adult descendants in the 1953 deeds?
In large part, yes, Your Honor. And the
If it
appellants
meant-
agree.
If it meant just those descendants that were adults at that time, that's one position. The other one is, does it mean to any descendant that is an adult when the offer is made?
That's correct. The former is their argument, and the latter is what the trial court held.
So that's really
I think
I
in large,
understand all the proof and everything,
Yes.
but that's really the dispositive question, right?
probably it is, Your Honor. And they concede that descendants means what everybody else thinks it means, children, grandchildren, issue across generations. But they argue that the adjective adult changes it from its normal meaning, meaning people who are descendants who are over a certain age, to the Hahn children. It simply doesn't do that. You can't, the regular rules of contract interpretation do not allow you to alter the normal meaning of terms. It simply can't be done. So I think, Your Honor, you have to look and see if within the 4 corners, is there anything that suggests that adult added on to descendants changes the meaning of the word descendant. I don't believe it does. I think it says we mean the ones over the age of 18, not just the ones who are currently over the age of 18. Going to TUSRAP, the trial court ruled that because TUSRAP uses the term non-vested property interests, and because these ROFRs are contract interests under Abbott and Riverside, that it doesn't apply. They don't argue otherwise. They do argue that the common law survived TUSRAP's enactment, and that's simply not the case. TCA 66-107, which is the provision titled Preemption of Common Law, provides in its entirety, quote, "This part supersedes the common law rule against perpetuities in this state." The, quote, "The intent of the legislature when it enacted TUSRAP was to abolish the common law that had bedeviled law students and courts and practitioners for years, and they wanted to save the gifts that continued to fail. So they in fact took the original common law that is now in TCA 66-1-201A1. They then added a 90-year wait-and-see provision. They granted courts the ability to reform the gifts, and they made it apply retroactively and prospectively so that there was nothing left on either side. There isn't anything else the legislature could have done to signal their intent that TUSRAP was to be the final word on the rule against perpetuities in Tennessee. If this isn't enough, Your Honor, there's nothing that the legislature can do to supersede the common law at any point. It would always survive enactment of statutes. And none of the cases that they have cited deal with supersession clauses like TUSRAP has, or apply forwards and backwards like TUSRAP does. And their argument with respect to unreasonable restraint also fails. No Tennessee court has held that a right of first refusal is an unreasonable restraint. Reasonable restraints are allowed, unreasonable restraints are not. But the court in the Tennessee Supreme Court in 1901 did come up with a test, and the language is very antiquated, but they said, quote, "These are valid conditions," this was a will that prohibited any part of testator's estate from passing to two specifically identified relatives and anyone bearing the name of Kelly, and the court said, "These are valid conditional limitations. It is well settled that any conditional limitations upon the power of alienation, which is so restricted as to not be inconsistent with a reasonable enjoyment of the fee, is valid. But if the condition be such that the fee shall not lien to such any one, naming him or any of his heirs, or the issue of such as one, or the like, which conditions do not take away the power of all alienation from the fee, then such condition is good." These rights of refusal do not take away their power of alienation. They may sell it, and they may sell it at the price they choose and when they choose. But it does trigger the right for these Hahn descendants who are 18 or older at the time it's triggered, Your Honor. It triggers their right to exercise it and preempt that person for $1 more.
If you would, maybe talk just a little bit about the second issue, about whether or not the trial court erred by giving your client, by awarding specific forms to your client and not requiring anything done to all the adult descendants.
As I mentioned earlier in subparagraph 2 of paragraph D of the prayer for relief, he specifically asked that the property be ordered to sell the property to the descendant who makes the offer. He, in fact, is the only one who has made the offer.
Was there any proof any of the other descendants?
Pardon?
Was there any proof that the other descendants knew of the offer?
Yes, Your Honor. They were originally in 2020. Let me back up. The Hahn family owns Title Guarantee and Trust Company in Chattanooga. In 2020, there was a meeting of shareholders, and Ms. Sandlin mentioned the Clements-Evett contract at that meeting and said that it mentioned the right of first refusal. Nobody did anything. Mr. Bacon, except Mr. Bacon, he made an offer. He continued to make offers. Then when the lawsuit was filed in 2022, I believe, they were all served with copies of the lawsuit. Then Ms. Sandlin and Ms. Poynton brought them all in as defendants. And at that point, they were in the lawsuit. They were parties to this lawsuit. They got copies of every single paper. It was an egregious waste of paper, but they got a copy of every single thing we filed, and that Mr. Alston also filed. They have been aware the entire time. When the trial court entered its memorandum opinion in September of 2023, I believe, and said, "Mr. Bacon, you win," they knew it then. They got a copy of that. When we had the hearing on the motion to alter or amend, nobody Nobody showed up. When the final judgment was entered, that was also served on them. They knew at that point not only had Mr. Bacon made the offer, but that the court had awarded the relief solely to him. They aren't here today, Your Honor. They've waived their right.
All right, thank you. You use your time. We'll hear from the
Thank
appellant
you.
rebuttal.
Your Honors, to hit the last point that you just addressed, to this day, there still has never been an offer made under these ROFRs for an adult descendant or for a Hawn Hill property owner to respond to. It is an actual affirmative act that has to happen. The fact that Mr. Bacon actually made an offer doesn't mean he made an offer in response to a ROFR extension of an offer, and that's where we are today.
Doesn't he just have to? Does he just have to say, "I want it"? I mean, if he has right of first refusal, then can't he just say, "Okay, I'm exercising that right, and I'm going to buy it at that price plus $1 more"?
Well, that's a really interesting question, because the problem with it, Judge, is that there are no specifics in the ROFR to say how the offer needs to be made, what mechanism, what happens if you have multiple.
Also, what if you get multiples? Yeah.
Right, if you have multiple offers. So it seems a little sleight of hand and creative, let's use that word, creative, to say that just because he is the only one who's made the offer, then nobody else responded to the offer, because there was no offer, and that's our whole point. And then secondly, as you mentioned, there is no mechanism put forth on multiple offers. What happens if 1,000,001 is offered by 10 descendants? What do you do then?
Just draw straws.
You know what? Maybe you have a bidding war. We don't know, but that goes to the restraint on alienation, Your Honor.
Counsel,
yes, sir.
Could you address the point referencing gratuitous transfers?
Yes, Your Honor. We understand that if you gratuitously transfer, then that would not extinguish. We don't contest that. As a matter of fact, that's actually part of the problem with the court's ruling, because it hinders and harms our clients by preventing them from gratuitously transferring. And if they give it to their kids, then that continues on forever and ever. And so we would say that the gratuitous transfer situation underscores another problem, and that is these ROFRs will be inextinguishable, because it would dissuade our clients from giving the property to their children. Your Honors, on the point about construing adult descendants and descendants, the McCarley case construed grandchildren as the living grandchildren to avoid a perpetuity issue, and that's exactly what we asked the court to do here, particularly in light of the Foster v. Hahn case and these actual children believing that the ROFR stopped with them. I believe that's about all the time I've got, Your Honors. So,
Perfect.
thank you.
All right, thanks to counsel for both sides. We appreciate your arguments today and your briefs on this, and I can't wait to see what we decide. Thank you all.